finish.
We should also be conscious of time.
Your Honor,
We have other matters that we have to deal with. We don't want to find ourselves in a situation that we found ourselves yesterday.
It is the court's time.
Court is controlling time. We had agreed.
Your Honor, I am most obliged by the protection granted by the court against the tyranny of the ODPP. Your Honor, paragraph 2 of the porter has indicated has given or listed the properties that are capable of being applied towards the commission of a terrorist act. Paragraph 2. Section 2, that of the porter, the definitions. One of those is the funds. The application before you is predicated on the availability of the funds. Therefore, if the inventory, the purported inventory, and I have to rely on it for lack of otherwise, as embarrassing as it is, if there was no funds that were captioned by the inventory, where are the funds? Who took them? Why did the IO take the funds belonging to a crime? Why has he interfered with the integrity of that crime, if it was otherwise committed? The absence of funds in the inventory can only communicate the lack of good faith in these proceedings as elucidated in the case of Oscar Sudi. There cannot be any other conclusion, Your Honor. Number 2, Your Honor, permit me to address you on the question of the terrorist property meaning. Again, the meaning of terrorist property. Terrorist property, again under Section 2, proceeds from the commission of a terrorist act, money or other properties. If money is lacking, they have not said that the member of parliament identity card was an accessory of or a tool of committing the crime. They have not told you the member of parliament's card that was a parliamentary card or his iPhone or anything were accessories. The case is predicated on the issue of money, and suffice to note, we have all agreed that the affidavit is laced and tainted with hearsay. Permit me as I sum up to address you on paragraph 33. Paragraph 33. A police officer who detains, of most importance, Your Honor, because I know you refer to the law, is paragraph 33, subsection 2. Section 33, subsection 2. It will become relevant when you're making your decision. Equally, section 33, subsection 4, and subsection 5. That they are not compelling. The court is being told, a court shall not make an order for the remand in custody of a suspect under subsection 4 unless there are compelling reasons for believing that the subject shall not appear for trial. But this compelling reason is not at this stage. It's when the trial itself has commenced. That's a distinction I wanted to make. Paragraph 30, section 35, on the circumstances under which the limitation of rights can ensue. Section 35, of most importance, is section 35, subsection 2, paragraph A, B, and C. Those are very important, and also subsection 3 of section 35, subsection 3. We urge you, Your Honor, to find that there are no reasons that have been brought before you. The same has failed to meet the test under the case of Oscar Sudi. Under this application ought to be dismissed and the respondents be set free. Your Honor, the respondents, but I shall make that application after you have made your decision. Again, permit me to just go slightly backwards. In the case of Oscar Sudi, again, look at paragraph 23 of the said authority and say what the judge is saying. 23, Your Honor. This is an act in futility. The application is meant to silence the dissidents, individuals who may not agree with the current existing status. Is a political persecution. It will almost amount to a detention without trial if the trial is based on speculation or the presupposed trial is based on speculation. Kindly put a lot of weight to the evidence that came out during cross-examination and the inability of the witness to answer the questions as put to him by the defense. Permit me to invite Mr. Mboro to distinguish.
Before that, Your Honor, I have 4 points. Just 1 minute.
Since you're on your...
Yeah, Mom, no, let me raise this issue.
Perhaps, Your Honor, because of the gravity of the matter, please bear with us. We ask our colleagues in the prosecution to just bear with us. It's critical. Thank you.
1 minute, Your Honor. I'm raising 4 constitutional questions in addition to what my learned colleague raised, which binds you. Yes. Yes. Yeah, my name is Ondieki. I'm a distinguished constitutional practitioner. Yes. And the 24-hour principle is known as the Ondieki principle.
I can attest to that.
Yes. Yeah. So, Your Honor, I just want to raise 4 issues which cover on the principles and values of the Constitution. Number 1, look at the preamble, the issue of recognition. Your Honor, in the preamble to the Constitution, Kenyans thank God for giving them a new Constitution. And then the preamble, they said, recognizing the aspirations of all Kenyans, that they want a government based on human rights, equality, freedom, democracy, and the rule of law. And those values, Your Honor, are replicated in Article 1, Article 10(1), and Article 10(2). Your Honor, a member of Parliament is not anybody. A member of Parliament under Article 94 is having a constitutional mandate to oversight the executive and also approve budget for the judiciary. Now, all of a sudden, this member of Parliament can't even move. He is a perceived terrorist on suspicion. So I ask you to look at that aspiration. Number 2, Your Honor, as you retire to consider this ruling, I want you to look at Article 24, Clause 2C. It is very specific that even when you are being moved to restrict a right or limit it, you should not limit it to the point that it derogates from its core or essential content. My learned colleague espoused those rights of liberty, dignity, and freedom to associate. Your Honor, even when you want to limit, you cannot limit it to the extent that it deletes it is essential content. And Your Honor, 14 days removes that essential content of that right. I want to take you now to the third issue which I'm raising, which is under Article 49, 1F. That's what I want you to look at. This application is there to limit the rights of the respondents for 14 days. They are not even sure. They came with 30. They downgraded to 14. But Your Honor, what is the threshold? The threshold is found in Article 49, 1F Roman 1 and 1F Roman 2. It says if you arrest any person, then you have to bring him to court, which is a court of competent jurisdiction, within 24 hours. So what are the exceptions in this case? If there is anything that they want to limit their rights, then the threshold you want to measure is 24 hours, because the Constitution has defined when you have to bring somebody to court. So asking for 14 days, Your Honor, is not reasonable in a democracy, in a country that respects the rule of law, in a country that is a member of the Commonwealth and a member of the United Nations. Now, my learned colleague talked of the autonomy of the Office of the Inspector General and the ODPP. Your Honor, on that issue, I asked you to look at Article 249, Clause 1A and 1P. 1A, and I can explain the brief historical background. Article 249, Clause 1A and 1P. Your Honor, Senior Counsel explained the background of the registration, the enactment of the 2010 Constitution. Why did the 2010 Constitution create so many commissions and independent offices? You find that in Article 249, 1A and 1B. Your Honor, in 1A, it says that constitutional commissions and independent offices must protect the sovereignty of Kenyans, democracy, and constitutionalism. What is constitutionalism, Your Honor? Constitutionalism simply means a limited government. That's why there are checks and balances. That's why these institutions were created. And that's why there is parliament, there is the judiciary, and there is the executive. And then there are independent offices which should implement this constitution. So what, Your Honor, I'm saying, in exercise of their constitutional mandate, they cannot come here and swear to breach the constitution which they have sworn to protect, promote, and fulfill. You will get that in Article 21, Clause 1. All state officers, all state organs are obligated to observe, promote, protect, and fulfill the human rights, which my learned colleagues have indicated. So in a nutshell, what we're saying is this, Your Honor. There is no competent application before you to warrant you to issue orders.
Michael Rotich versus Republic. It's a 2016 Kenya law reform. So, Your Honor, the emphasis is a charge or a holding charge. So, I want to quote with your very kind permission, and it says that the recent trend where a person is arrested and arraigned in court within 24 hours, Michael Rotich versus Republic, it's a 2016 decision. Should I proceed, Your Honor? Yes. So this is what the learned judge said. That is Justice Kimaru in that matter said that the recent trend where a person is arrested and arraigned in court within 24 hours, specifically for the prosecution to seek extension of time to detain such person without any charge or holding charge being preferred against them, is unconstitutional. So that is what the judge said. So, Your Honor, Your Honor, and that decision is binding upon this court. And we remember that 3 days ago when we appeared before this court in other matters, the prosecution had presented a holding charge in respect of some of the suspects and also charge sheets in respect of the others. So in this particular case, neither a charge or a holding charge has been presented before this court. So this is what the court continued to say, that such holding charge will enable an accused person to know of the reason for his arrest as provided under Article 49A of the Constitution. It will not do for the prosecution to present a person who has been arrested in court and seek his continued detention without a charge or a holding charge being lodged in court. Your Honor, none has been lodged before this court, neither a holding charge or a charge itself has been lodged before this court. And the judge continued to say it is unlawful for the police to seek to have a person who has been arrested to continue to remain in its custody without a formal charge being laid in court. So, Your Honor, I think it is very clear from that particular provision that without a charge or a holding charge, the continued detention of the suspect or respondent hearing is unconstitutional. And, Your Honor, that has a basis because the reason why a charge or a holding charge is required is so that the the suspects are able to properly understand which particular charge they are facing. So in this particular case, the miscellaneous application that is before you lacks specificity in the sense that it does not specify which of the respondents is being charged with which particular offense. And that was the whole basis why the court was saying that there has to be a charge or a holding charge, so that the accused person properly understands which charge has been presented as against them individually, or if it's collectively, then that has to be clear. So, Your Honor, that decision has been supported by, in the Oscar Sudi case that has been stated by my learned friend, Mr. Ndegu Anjiru. And Professor Joel Ngugi, in agreeing with that position, said as follows, that there are good reasons for this purposeful reading of the Constitution. Why should the police arrest a citizen if they do not even have a provisional view of the offense the citizen has committed? It would seem repugnant to the ethos of constitutional justification of the exercise of power and authority in which our Constitution is steeped to encourage such practice, even if not categorically and unconstitutional textually. So in many cases, such police action would be, in the context and effect, unconstitutional. This would be the case where the police conduct reveals a pattern or desire to overreach or to deploy the criminal justice system in a manner which unnecessarily diminishes the personal liberty or autonomy of the arrested person. So this is exactly what is happening, Your Lordship, Your Honor, that the criminal justice system in this particular case is being used to settle political scores, or not to, otherwise a charge or a holding charge would have been preferred as against the respondent. So, Your Honor, there was another issue that was Mr. Ndegwa had pointed, that is section 33(5) of Porter. Your Honor, and that provision is very clear, subsection 5. A court shall not make an order for remand in custody of a suspect under subsection 4C unless A, there are compelling reasons for believing that the suspect shall not appear for trial. That is the first compelling reason. Your Honor, look at the application and the affidavit. None has been deponed to show that either of the respondents will not appear in trial. The other one is, the other compelling reason is interference with witnesses or the conduct of the investigation. So, Your Honor, this is the darling of the prosecution. This is what they are saying is what they need for them to conduct the investigation. So, and Your Honor, if you look at paragraph 9 of that affidavit, as well as this was confirmed in cross-examination by the accused person, so they're saying that under paragraph 9, they're saying that the investigation team is yet to conduct the following. Number one, recording of statements from witnesses and victims, forensic analysis of mobile phones, which they confirm they have already collected, retrieval of financial records connected with the respondents, and Your Honor, they have confirmed that they are in possession of all these items. So the only thing they require is for them to analyze. So, Your Honor, the question is whether the respondents need to be detained for this to proceed. So, Your Honor, and I have an answer where the court in the case of Betty Jemutai versus Republic, it's a 2018 decision. It has answered that question for Your Honor. It will be very easy for you. And this is what the court said, that I do not find that the police offered good reasons for the continued detention of the arrested persons, because the matters used to justify the detention being aspect of investigation. Number one, by taking witness statements, obtaining call data from applicants, and securing forensic report on cyber crimes. All these things could have been accomplished even with the persons all being out of custody. So, Your Honor, the respondents need not to be detained for the prosecution to be able to conduct this investigation. In any event, it was on cross-examination, the IO confirmed that these analyses are done without at the DCI headquarters, where the respondents neither work nor have access to those particular facilities for purposes of conducting those investigations, those analyses. So, Your Honor, in the end, what we are saying is that there is no need to detain the respondents, as the prosecution can still conduct that investigation without the respondents. And Your Honor, the other issue of interference of witnesses, there was a decision that was quoted by the prosecution, that is Njao versus, and two others versus the Republic. Your Honor, and I think counsel should have properly informed the court of the import of that decision, which we are going to differentiate right now. In that particular case, the court actually laid out the threshold for the court to consider in terms of interference of witnesses. And at paragraph 14 of that decision that was quoted by the prosecution, the court stated as follows in terms of the threshold for interference, that accordingly, the specific instances or likelihood of interference with witnesses must be laid before the court with sufficient detail or evidence in support thereof as to persuade the court to deny the accused person bond on this ground. So, Your Honor, it was very clear that in this case, the court had already laid out that sufficient detail and evidence must be provided. In this particular case, Your Honor, the witnesses are yet to be identified by the prosecution, and no evidence has been provided to show that the accused persons, the suspects, will interfere with witnesses who are actually unnamed. And in that case, whereas the holding is what they say, that was because the prosecution in that particular case was able to list the witnesses and actually provided evidence that other witnesses refused to testify on that case. So there was sufficient evidence in that case which warranted the court to make a determination that actually they would have interfered with witnesses. But in this case, none of the witnesses has been shown. No OBS extracts have been presented to show that anyone has complained of any interference from the respondents. In fact, the only reason they have is that they are saying that they accused the first respondent, because he's a member of parliament, has the capacity to interfere with witnesses. Your Honor, and I have a decision in the case of Panju versus Republic. Panju versus Republic, it's a 1973 decision. PANJU versus Republic. It is a 1973 East Africa law report.
What do we do now? I think much of it has been said.
Your Honor, and that in that particular case, the court was very clear that the court will not deal with speculation. as is the case herein. This is just because someone is a member of parliament without providing material before the court to show interference is speculative. And the court said that in dismissing the prosecutor's fear of interference with witnesses, the court stated that before one can say there would be interference with vital witnesses, at least some facts should be led to the court, otherwise it is asking the court to speculate. And we do submit that what the prosecution is doing is speculation. There is no evidence whatsoever that has been presented before this court to indicate that the first respondent will interfere with the witnesses. So finally, therefore, Your Honor, what then does the court need to do under section 33(5) of Porter? So I have already said that for the compelling reasons, there is no reasons in terms of interference of witnesses. B, said that it is necessary to keep the suspect in custody from the protection of the suspect, where the suspect is a minor. So in this case, Your Honor, there is no safety concern as to the respondent. In fact, the first respondent is a member of parliament who is section 33(5) of Porter on what the court needs to consider in an application like this. C is the suspect is serving a custodial sentence. In this case, that is not applicable. And D, the suspect having been arrested in relation to commission of an offense under this act has breached a condition for his release. Your Honor, that is not applicable in this case. So it is therefore our submission that this application lacks merit, and we do pray that the respondents be unconditionally released based on the authorities that we've already mentioned.
Thank you.
I am most obliged.
Thank you. Kungo, if anything, in 1 minute, because we want the ruling to be made. These guys are in custody.
Your Honor, I believe we can now go
Yes.
so Mr. Kungo will be voting Mr. Abata.
Oh, okay. LSK then.
Yes, and Your Honor, in the interest of time, I'll strictly give myself time.
No, we want this ruling.
That's why I get advantage position.
The response is
Yes, Your Honor, I want to. Gorenga is my name.
Yeah.
Gorenga is my name, Your Honor. Yes, Your Honor, I want to briefly address the court on internationally agreed principles on pretrial detention, and my submission will be premised on Article 9, Sub-Article 3,